whether they're violating the ordinance or not. But the city apparently knows. I was surprised to see the aerial photographs and to know that the city's tracking where camps are. But if I understand the city's argument, just with regard to place, 62% of the camps are in violation of the ordinance. 28% because of they're in a prohibited location, and 34% because they're blocking ADA access. So 62% are violating place. All are violating time. All of the plaintiffs are violating the time restrictions. And the city says we would have complained if it were nighttime. You know, it's not my job to come up with a reasonable ordinance. I'm not qualified. But having spoken to people and having looked at the expert declaration, having some places where people could sleep in the daytime would be more reasonable. Having some places where people could sleep 24 hours a day would be more reasonable. And having other places where people can only sleep at night, I mean, that would start to approach more reasonable. And so it's my belief that all 5 of the plaintiffs at all times or at some times are violating the time and place restrictions. And there's nothing, I mean, I don't know if that qualifier in sub 6 is just with regard to attorney fees. We're a long way from there. But, you know, and also we may add plaintiffs as we approach class certification, but my belief, I mean, we had 24 plaintiffs that we put in our letter to the city back in July. These 6 we move forward with as plaintiffs because they are representative of the class of homeless people in general. I mean, we strategically pick them for that reason. Now, people's lives change. Hopefully, folks get housed. Hopefully, people get shelter. Some people leave town. Things can change, but they're not vindicating anything that's unique to them, to my knowledge. Their situation is representative of what is happening out there. And unfortunately, I think they're in violation of the definition of campsite, the time restrictions for sure, and probably the place restrictions. But the part of the problem is they don't know.
Okay, the city.
So, and just to clarify, the city's not disputing that plaintiffs are homeless, at least based on their declarations. I think they do meet the definition of homeless. But with respect to irreparable harm, based on the declarations, and again, presumably plaintiffs have more information about where they're sleeping. But what they've said in the declarations is that they, I believe 4 or 5 of, I think there are 5 of them now, 4 of them pack up their belongings during the day and keep them with them. That's the opposite of violating the time restrictions. That is complying with the time restrictions. One individual who indicated that he did prefer to sleep during the day because he had felt unsafe indicated that he didn't indicate whether he sets up a campsite during the day, and he said he often sleeps on MAX trains, but wasn't sure whether that was prohibited. Looking quickly at the MAX rules, it doesn't look like it's prohibited, but again, that doesn't relate necessarily to the ordinance. In terms of the place restrictions, again, I think that they've chosen to assume that they're violating the place restrictions in order to assume that there's irreparable harm. But in fact, if I had the address that they were sleeping at, I could look it up right now on my computer, or my co-counsel could, and tell you whether they're violating the place restrictions or not of where they set up their campsite overnight. So based on the evidence that plaintiffs have put in, there's no evidence that they are in fact doing anything that runs afoul of the ordinance. There's no violating the definition of campsite. The definition of campsite just determines kind of how the place and time restrictions apply. And so I think for these individual plaintiffs, there are 5 of them. Plaintiffs' counsel has purported to represent a class of, I believe, involuntarily homeless individuals. But that isn't what we have before us right now. We have the plaintiffs, and we do not have a certified class. And And an injunction is an extraordinary remedy. It would limit the city's ability to do anything about this and enforce in any manner, and at this point in time. And the courts have recognized that this is, that enjoining an action is an extraordinary remedy that should be focused and limited and address only issues where there are, especially a preliminary injunction, where there is a likelihood of success on the merits and irreparable harm demonstrated by plaintiffs during the course of the litigation.
Okay, thank you. Regarding ORS 195.530, subsection 2, objectively reasonable as to time, place, and manner with regards to persons experiencing homelessness. I've read the city's motion and declarations. Is the city relying on the public comments, time and area in evidence they're presenting to the court regarding the objectively reasonable as to persons experiencing homelessness?
No, Your Honor. I think that was just to demonstrate kind of the process of what the city did here. And that includes testimony as well as public comments, but the public comments aren't as easily accessible online. That was the reason they were included. In terms of objectively reasonableness, the city's position is that that is a question of law that the court needs to determine, and that question of law is the question of law that comes from the statute and comes specifically from what the legislature was relying on, which were the limitations that were imposed by the Ninth Circuit under the Eighth Amendment under both Boise and Grants Pass, which is what they were trying to operationalize here. So that question of objectively reasonableness, I think, is not a question that's answered from a particular person's perspective. It's not, they mentioned having declarations that all said this is objectively not reasonable. And the city doesn't put that in because that, as far as the city is concerned, that's putting in a declaration as to the ultimate question of law that really is a question for the court to answer, based on, again, the legislative history that confirms that the intent was to ensure that it was not unfair in terms of being able to engage in the minimal necessary requirements for keeping warm and dry if there is no shelter available.
Thank you. Mr.
I just wanted to address one of those points, which is I don't think objectively reasonable, since it's based on the totality of the evidence, including impact of people experiencing homelessness, is a legal question. I mean, what that means could end up in a jury instruction. I mean, you're sitting as the judge in this matter right now, but that strikes me as a fact question. And at this stage, the question is whether or not the plaintiffs have presented facts that indicate that they're I keep forgetting the language, and that it appears that they're entitled to relief. And all of the facts that have been presented in the form of declarant testimony weigh heavily in plaintiff's favor that this is not objectively reasonable. I don't see how the court can answer whether this ordinance is objectively reasonable as a matter of law. Certainly not at this stage, but I think ever. I mean, we may, I have to admit, I haven't thought that through fully, and our ideas may evolve as this case progresses. But at this stage, no one's asking this court to determine whether or not this ordinance is objectively reasonable. The question is whether or not plaintiffs have shown that it appears that they're entitled to relief and that they will be harmed over the next several months if the ordinance is enforced against them. And it's preliminary. If the city wins on the merits, which we don't think they will, they can just start enforcing the ordinance. If we don't get our preliminary injunction and we prevail, the final judgment will be ineffectual for many of the plaintiffs. So yeah, that's the only rebuttal point I had on that.
Okay. And I want you both, and we'll start with the plaintiff, to address, the city has suggested that an option for the court is to sever provisions of the ordinance. Can you address that point?
Yes, so there's actually, yeah, I think there is a third way. I don't, does anyone remember Bill Clinton? He always talked about the third way, but here I think the third way